Hi everyone, Jasmine here from Redwood. This week's frequently asked question is, what grounds do I need to contest a will? That's a really interesting question. Contesting a will is not an easy process, and although anyone can contest anyone's will in the UK, it doesn't actually mean that you've got any legal merit or good standing that you're going to be successful in any way, shape or form. The common ways in which, or the common reasons for contesting a will, primarily are going to come around things like mental capacity and undue influence, financial dependency, and also promises. So mental capacity and undue influence. If you feel that someone has been unduly influenced or they didn't have the mental capacity to make the will, and as a result you feel that you've been left out of their wishes or not been left anything or as much as you were originally thinking that you were going to be left, then there could be grounds for you contesting that will on the basis of whether or not that person had mental capacity or whether they were being pressured by someone to cut you out of their will. Of course, the difficulty is there's a burden of proof here that you have to try and prove that someone didn't have the mental capacity or someone acted in undue influence. So it can be hugely costly in terms of legal fees, but also investigative fees to try and actually ascertain if any undue influence took place. And how you assess someone's mental capacity now they're no longer here is, of course, very challenging. The other grounds on which you might contest a will is financial dependence. So whilst in the UK we do have testamentary freedom, which means we're able to leave our assets to whoever and however we want, fundamentally there are some safeguards in law to make sure that our financial dependents are taken care of. So we don't leave our children, for example, who are financially dependent on us without any inheritance, making them now a burden on the state. So if someone has been cut out of the will and they can prove that they had a financial dependency or an expectation of financial dependence from that person, then the courts might find in favour and award them something, if not everything, from the estate that they are claiming for. The other possible way of contesting a will is on the basis of a promise. So there are some examples in case law where someone has made a promise. So perhaps I've promised that if you work for half your hourly rate that you're supposed to work for me, when I die, I'm going to give you my business or my land or my property. And so you've worked at a discount in the good faith that you're going to get paid with dividend and interest effectively when I die, because I'm going to leave my assets to you. If I ultimately didn't follow through on that promise, even if that promise wasn't in writing and was just a verbal contract between the two of us, there could be grounds to contesting the will and trying to claim something against the estate to compensate for the fact that you've worked at a discount in the good faith that you were going to receive something when I died. So the key thing is making sure that your instructions are really clear. After you've died, you're not able to defend your wishes or instructions. So it is going to be how you speak through your will and your wishes letter that a judge is going to be looked at. If you've left a beneficiary out of your estate who you think is going to cause a fuss or is expecting or feels entitled to something, then document why you've left them out and give the judge as much understanding as possible so that they can look at that as part of the overall picture. The advice really as well is, if you do have a situation where you've got beneficiaries that you're not wanting to include and deliberately exclude from your estate, then the use of a trust can be really beneficial as well to helping do that. So that's today's frequently asked question. I look forward to seeing you next week for our next question.